Later today, November 12, AIIP and the Union of India/LIC goes back to the Supreme Court. First and foremost, it's crucial to understand the Supreme Court's judgment, delivered on February 20, 2024, was a final judgment. The primary appeal is over. The Retirees Union won a final and binding judgment.
That's right. The case, in its original form, is concluded. There will be no further hearing for the civil appeal itself. The court has rendered its verdict, quashed the discriminatory LIC office memorandum, and issued specific binding directions.
Indeed, it's safe to claim, isn't it, that right now on pension, updation and DR, the government of India is drinking in the last chance saloon with closing time only 1 second away.
I like the last chance saloon analogy.
Notably, the most critical question regarding the latest status is not procedural but practical. Has the Union of India complied with the judgment? As of today, the 3-month compliance window has long since expired.
The Union of India, being the losing party, has the right to file a review petition within 30 days of the judgment. This is a request for the same bench, if available, to review its own judgment. This is a common delaying tactic.
And the core issue that really boils down to this, pension parity.
Should all LIC retirees get the same pension adjustments, the same dearness allowance updates, no matter when they retired?
Right. Because right now they don't. And that's led to this big appeal, civil appeal number 3465/2024. It's the All India Insurance Pensioners Association against the Union of India.
And the stakes are enormous. We're talking about potentially huge financial implications for LIC. They've quoted a figure, haven't they?
Yeah, a staggering one, 32,000 crore rupees or 3.7 billion US dollars. That's what LIC says is on the line.
Okay, so let's start with that court status. The documents mention the case is part heard. What does that actually mean in practical terms? It sounds important.
What does part heard mean?
It means incredibly important. Part heard is judicial speak for this is top priority.
So the judges have begun listening to the core arguments.
Exactly. And the court system gives these cases precedence. The idea is to finish the hearing, usually before the very same judges who started listening, before they move on to, other final hearing matters. It signals commitment to a final decision.
Okay, so highest priority, same judges, commitment to finish. That must be significant news for LIC pensioners waiting for news about the case.
Absolutely. It means the end is potentially in sight. And we know there's been recent activity. Arguments continued just last month, October 9th, and there were directions for filing compilations by late October. Things are moving fast now.
Good to know. Just a quick note for listeners. The case number is 3465 of 2024. There's another case, 3465 of 2023, totally unrelated, something about UP Education Service matters. Just so no one confuse the two cases.
Right. Good clarification. Different year, different case entirely. Our focus is the 2024 LIC appeal.
Okay. So let's dive into the heart of the matter, the legal principle versus the financial reality. What's the core complaint from the pensioners? What exactly is this parity they're demanding?
Well, the fundamental issue is how the basic pension is calculated. Right now, an LIC employee's pension is based on their salary at the moment they retired.
Okay.
But crucially, that initial pension amount, the basic figure, it was never adjusted upwards when LIC later revised its pay scales for active employees. And those revisions were substantial, happening over decades, 1986, 1993, 97, 2002, 2007.
So, wait, if I retired in, say, 1990, my pension is stuck based on 1990 pay scales, but my colleague, same job, same rank, retires in 2007, their pension starts at a much higher level because the scales changed.
Precisely. That's the disparity. You end up with, as the petitioners argue, the different classes of employees based on their date of retirement, even if they did identical work.
That sounds inherently unfair on the surface. What's the legal basis for their challenge, Dee?
They're leaning heavily on the principle of equality drawn from the landmark Supreme Court case, DS Nakara. The argument is essentially that pension is like deferred pay, and you can't arbitrarily discriminate in its calculation based just on when someone happened to retire. It's akin to one rank, one pension, or ORP.
And they also brought in Article 21, the right to life, didn't they? How does that connect?
Yes, they connected it to the minimum pension issue. They point out that LIC did increase the minimum pension over the years from, say, 375 rupees back in 86 to over 3,000 rupees by 2012.
Their argument is whenever you enhance or liberalize that minimum flow, that benefit should automatically flow to all pensioners currently drawing less than that new minimum, regardless of their retirement date.
It's framed as essential for dignity and the basic right to sustain oneself under Article 21.
That's a powerful argument linking it to fundamental rights. But LIC must have a strong counter. What's their defense? It seems to revolve around this idea of being fund-based.
That's the crux of LIC's defense. They stress that their pension scheme is fundamentally different from, say, central government pensions.
How so?
Government pensions are paid from the Consolidated Fund of India, basically, the general government budget. LIC argues their pension comes from a specific, separate, dedicated fund.
Okay, a ring-fenced pot of money.
Exactly. LIC contributes 10% of employee pay into this fund, and they make additional contributions each year based on actuarial calculations. They have to ensure the fund is sound. They're saying, we operate under strict financial rules for this fund.
So unlike the government, they can't just draw from general revenues. They have to keep this specific fund solvent according to certain rules.
They argue this makes cases like DS Nakara, which dealt with government pensions, less relevant. They point to other precedents, like Krishna Kumar v. Union of India, which dealt with specific funded schemes, arguing those are a better legal comparison.
And do they acknowledge the disparity at all?
They do, indirectly. They mention that their due notice relief formula is actually structured to be slightly more beneficial for those who retired earlier, say before 1993 or 1997, compared to later retirees. Sort of an attempt to mitigate the gap, but clearly not enough in the pensioners' view.
Right, so it's a clash between the equality principle and the specific financial structure of LIC's fund. This fight didn't just spring up, though. Can you trace the history? How did it get to the Supreme Court?
Oh, this has been a long journey. It started years ago in various high courts. One of the key early battlegrounds was the Rajasthan High Court.
And what happened there? Our sources seemed quite dramatic about it.
It was dramatic. Back in 2011, the Rajasthan High Court, looking at the Krishan Murari Lal Asthana case, made some really strong observations. They noticed something quite startling.
Which was?
That LIC's own board of directors had actually passed a resolution way back on November 24, 2001. And that resolution specifically aimed to eliminate this pension disparity.
So LIC itself agreed internally to fix the problem over 20 years ago?
According to the High Court's findings, yes. But then LIC didn't implement its own board's decision for a decade. Their reason? They claimed they were waiting for approval from the Ministry of Finance.
Ah, that old chestnut, the bureaucratic hurdle excuse. How did the court react to that?
They were not impressed. The division bench justices, Dalip Singh and Mahesh Bhagwati, were scathing. They called LIC's appeal against implementing parity an eyewash and a sheer misuse of the judicial system.
Wow. Eyewash, that's incredibly strong language from a high court.
It was. They basically said, LIC is a statutory autonomous body and shouldn't need government approval for every single internal decision, especially one its own board had agreed on. It suggested the delay wasn't entirely unavoidable.
That context is crucial. It shows LIC retirees weren't just fighting a rule but also significant institutional inertia, possibly even resistance despite internal agreement.
Precisely. And this situation, with cases also pending in other high courts like Punjab and Haryana, led to the next major step. In 2016, the Supreme Court intervened.
What did they do?
They issued a Centralisation Directive. They ordered all these related pension parity cases transferred from the various high courts to the Delhi High Court. The explicit aim was to get a singular judgment passed to avoid conflicting rulings.
So consolidate the fight in one place to get a definitive ruling, which then sets the stage for the appeal we're seeing now at the Supreme Court.
Exactly. The Delhi High Court judgment eventually led to the current civil appeal 3465/2024.
Okay, now let's talk about the money because the figures are just mind-boggling. LIC is claiming a potential hit of Rs 32,000 crores or 3.6 billion US dollars. Why is their number so astronomically high?
This really gets into the weeds of actuarial science and accounting standards, specifically something called AS15, the projected unit cost method.
Right. What does that method require?
It forces LIC, as a financial institution managing long-term liabilities like pensions, to account not just for the money owed to current pensioners if parity is granted. That's part of it, the back pay or arrears.
Okay.
But the massive cost comes from having to calculate and provision for the future pension liability for every single current employee who has opted into the pension scheme over the entire future lifespan of all these current workers, factoring in pay rises, longer lifespans, etc., and book that liability now.
So it's not just about paying arrears to those already retired. It's about putting aside today the estimated total future cost for everyone still working, too.
Precisely. They argue that under accounting rules, they need to have that T2,000 crores basically set aside in the fund immediately to cover all those future promises, or the fund becomes actuarially unsound. It's a regulatory requirement for them, they claim.
That's a heavy burden. But the pensioners, they dispute this figure, right? What's their calculation?
Yeah, they have a very different perspective. The employee associations argue that the actual cost of arrears, the back pay owed to currently retired people for the period, say 1997 to 2017, is much, much lower. They estimate it at around 3630 crores.
Okay, that's a tenfold difference. 3,000 versus 32,000 crores. How do they justify the lower number?
They focus on the existing pension fund. They point out that the fund corpus was already substantial. Something like Rs 38,925 crores is back in March 2016. And this fund earned significant interest. They mention around 9% annually.
So their argument is look at the huge pot of money already there and look at the interest it's earning. Surely that's enough to cover the actual arrears for current retirees without needing this massive extra provision.
That's the essence of it. They see the large corpus and its earnings as sufficient. But LIC counters strongly, saying this view completely misunderstands or ignores the strict actuarial valuation rules they must follow, such as accounting for all future liabilities today.
So it's a fundamental disagreement on accounting principles and risk management for a financial institution versus a focus on immediate equitable distribution for past service.
Yes, textbook fairness versus financial regulation in a nutshell.
As we wrap up, it's important to step back and see the bigger picture. This LIC case isn't happening in isolation, is it? It connects to broader issues in the public sector.
No, definitely not. The source materials make it clear there's a wider frustration among LIC employees and probably in other public sector undertakings too. For instance, the issue of wage revision.
That was mentioned. The situation there?
Well, the wage revision for LIC employees was due way back on August 1st, 2017. That's over 8 years of delay. And even when LIC management reportedly improved its offer to around 15% in late 2020, it still got stuck, apparently waiting for approval from the finance ministry.
So it echoes the pension issue, internal agreement or progress getting held up by government oversight or delay.
It seems to be a pattern, and this leads to a broader call we see from the employee associations in the documents.
They want more autonomy for LIC and similar bodies like the General Insurance Public Sector Association, GPSA, to actually settle these wage and pension matters themselves.
They want That seems to be the core demand. They feel the central government's involvement slows things down unnecessarily and can even block agreements reached internally.
Yeah, it really does. And the outcome of the Supreme Court case, given the huge sums and the invocation of DS Nakara, it feels like it could have ripple effects.
Oh, undoubtedly. It could set a major precedent for other public sector undertakings, especially banks, many of which face similar legacy pension issues and funding questions. How the court balances the Nakara principles with the fund-based arguments here will be watched very closely.
Well, thank you for breaking down this complex case for us.
And thank you our listeners for joining us on the deep dive. Please subscribe, comment and like. We'll catch you on the next one.